90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. This show is part of the inauguration of our 34th year on WHPC 90.3, and also now carried over the web at nccradio.org. So welcome again, and we look forward to a year full of show of information for lawyers and people out there about all facets of the law. And my special guest today is tenant and landlord attorney Linda Rzesniowiecki. She's a very prominent attorney covering the many of the courts in New York City, mostly on behalf of tenants, but also on behalf of small landlords. Linda, welcome back to Law You Should Know.
Thank you, Ken. Today, I just want to say a few words about myself.
Sure.
I've been practicing landlord-tenant law for decades now. I've been on my own since 1996 after spending 10 years working for the city of New York. I was based in Manhattan for many years, and now I'm firmly ensconced in the fair borough of Brooklyn, but I travel. Have subway, will travel.
And I know, among other things, you're very knowledgeable about all the details, the intricacies of landlord-tenant law. It's a very complicated and unique area of the law. Linda, I know you are in the landlord-tenant courts, the housing courts, every day on behalf of tenants and also small landlords. But you're also concerned about the future of the rent stabilization law, and it's being litigated in other courts, and a decision may be several months away, but the possible decisions could mean the end of the rent stabilization law as we know it. So just tell us about your concerns.
Right. Yeah, I'm concerned about it. There is a challenge. The landlord groups, the CHIP, Community Housing Improvement Program, and the Rent Stabilization Association have filed a petition for certiorari in the United States Supreme Court. They filed this in May of 2023. Now the Supreme Court comes back to work in October, and then we'll see what they will do. Now, how did we get to this point of a petition for certiorari to the Supreme Court? Obviously, something happened in the courts below. What happened was that after June of 2019, both of these landlord groups filed a challenge to the rent stabilization law in the Eastern District of New York Federal Court. And the Eastern District dismissed the challenge in 2020. And then the landlord groups appealed to the Second Circuit Court of Appeals. And the Second Circuit affirmed the Eastern District of New York decision in February of 2023. And the landlords groups promptly petitioned to the Supreme Court for certiorari.
And I just want to clarify for our listeners, the petition for certiorari is the landlords are asking the U.S. Supreme Court to hear an appeal of the decision of the court below.
Exactly. One must ask the permission of the United States Supreme Court, and they must say, no, we won't grant permission, and that's all they'll say. Or they say, we will grant permission. Then we're in for a wild ride. Both landlords and tenants are in for a wild ride.
And we don't know what the position of the court may be. They haven't even heard the court yet. But the U.S. Supreme Court may be viewed as more conservative and more landlord friendly than those courts below that denied the landlord's request.
Right. That might happen. Before I get into that, what I want to mention is why did the landlord group start a case now? What prompted them to start a case now? There was in June of 2019, the New York State Legislature enacted the Housing Stability Tenant Protection Act of 2019, a far-reaching, very tenant-oriented law. And what that law basically aimed to do was make it difficult for landlords to wiggle out of rent stabilization in any way, shape, or form. And I wanted to talk about that Housing Stability Tenant Protection Act for a bit.
And we'll go on to that in a moment. I just want to clarify for our listeners. So that's what keeps rent stabilization in effect, at least in the city of New York and maybe other places, and gives tenants all kinds of rights and limits the circumstances under which landlords can go to market rates from the rates controlled under rent stabilization.
One thing that the Housing Stability Tenant Protection Act did is that they absolutely repealed something called luxury deregulation. There used to be a law that said if the rent was over $2,000 and if the rent was over $2,000 and the tenant's income was $2,700 a month, then the rent could be deregulated, luxury deregulated. That's no longer the law.
And what about vacancy decontrol? If someone passes on or moves out of an apartment, does that still exist, or would that be
that doesn't exist? Vacancy decontrol doesn't exist anymore. The apartment would have to be rented as a rent stabilized unit to the next tenant.
Yeah. So this luxury deregulation, it gave credence to the myth or the assumption that if people earned above a certain income, they didn't need the protection of the rent control laws or the rent stabilization laws.
Right. And the fact is, in New York City, you've got to earn quite a bit of money to survive here. So that high income, high rent law was very onerous to tenants.
And these are regulations for older or existing buildings. If a landlord builds a new building, they're allowed to just charge the market rate, whatever the market will bear?
Exactly. The rent stabilized units are units built before 1970, buildings built before 1974 that have 6 units or more. Okay. And those are the rent stabilized units.
But the landlords, of course, want to charge market rates because there could be the difference can be thousands of dollars between the market rate and the capped rate under rent stabilization.
Right. So the newer buildings, that's a free-for-all. Market rate rents.
And even apartments that have been previously deregulated, those are also going for market rates within those older buildings.
Exactly. There's a lot of, there was a great loss of rent stabilized units over the years for various reasons, and the legislature is trying to close all loopholes, regarding getting out of rent stabilization, and also closing loopholes by way of how landlords could increase rents.
Anyway, let's continue with your discussion about this very important topic.
I wanted to talk about the Housing Stability Tenant Protection Act for a little bit because that's what made big landlords and small landlords very, very angry and caused them to run to the Eastern District, New York, with a complaint. For instance, it used to be that owners could recover one apartment or more than one for personal use in their building. Now, the Housing Stability Tenant Protection Act says owner may only recover one apartment personal use. They repealed provisions which allowed landlords to charge a higher rent. There used to be a higher rent charged upon vacancy of a tenant, and depending upon how long the prior tenant lived in the unit. Also, landlords used to charge a low preferential rent to a rent-stabilized tenant at first, and mention in the lease that the legal regulated rent was like $1,000 more. And at the end of the first lease, when it was time for a renewal lease, the rent would jump up to that $3,000 mark, whether or not the tenant could manage it. The end of that, if a tenant starts with a preferential rent for the lifetime of that tenant, as long as the tenant is in that apartment, the rent stays the preferential rent. Also, rents were increased because of individual apartment improvements to an apartment and major capital improvements to a building. There are limits on those increases now that didn't exist before. And regarding conversion to a co-op or condo, tenants must consent to the conversion, and the percentage of tenants that must consent has been increased. And a little glass of water here. And finally, and the Eastern District of New York discussed this at some length, let's say a judgment of possession is issued against a tenant after a housing court proceeding for whatever reason, non-payment of rent, some wrongdoing. The housing court judge may consider keeping the tenant in the apartment for up to 12 months if there's a showing of unusual circumstances, like the tenant is in ill health, or the child is in school, in the school district, or what have you. At least the Eastern District of New York thought that was fairly intrusive, but not a taking under the Fifth Amendment.
So that's like in case a tenant has a problem, even though the landlord may have some grounds to evict them, that would stall the eviction?
Right. This is a post-eviction remedy. It's been decided that the tenant should be evicted, but there's a stay of the actual eviction. It could be up to 12 months. The judge considers that.
And that's the law now, and this is a provision that the landlord groups would like to get rid of.
Right. They'd like to get rid of all of it.
I just want to mention we're talking with attorney Linda Rzesniowiecki, and she's an attorney who concentrates on landlord-tenant matters and usually representing tenants and small landlords. As you've heard, her offices are in Brooklyn, and she handles cases in some of the boroughs of New York City and in other places. And right now we're talking about the challenge to the rent stabilization law, which currently exists and keeps rents from rising too fast and gives other protections to tenants, hundreds of thousands of tenants, especially in the city of New York. And you're listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. If you've missed any part of the show, just go to the podcast available at nccradio.org. Linda, I just want to go back to you and let you continue your interesting discussion about the challenges to the rent stabilization law.
Right. The landlord groups relied on many court cases in their petition for certiorari, but one particular case deserves a mention, and that is the case of Cedar Point Nursery versus Hasid, which was decided by the U.S. Supreme Court in 2021. What was that case about? That case was about land in this sense. There's a California regulation that grants labor organizers a right to take access to the property of an agricultural employer. For what reason? To solicit support for unionization. The regulation says employers must allow access to union organizers for up to 3 hours per day, 120 days per year. The Supreme Court held 6-3 that the California regulation constitutes a per se physical taking, struck down that California regulation because it was a taking of private property without just compensation, taking by the government without just compensation. And 6 justices voted in favor of this, and the 3 justices who voted against were Justice Sotomayor, Justice Kagan, and Justice Breyer, who is now retired. So 6-3. So that's pretty scary. And what landlords said about that case was that, hey, 3 hours a day, 120 days a year. How about us? We have an intrusion that's 24 hours a day, 365 days a year.
And it's also a taking of their property without just compensation because the amount they can charge is not the market rate, but artificially limited by the government or these regulations.
Right. The government has, in the city of New York, we have something called the Rent Guidelines Board, which decides how much rent should be increased. They meet every April. They come to a decision in June. And they consider landlords' costs, all kinds of things, but they also consider tenants' ability to pay. And that's what sticks in the landlord's craw.
And that's also there's still not. It just gives them relatively minor increases. It keeps it far below. It keeps the rent stabilized apartments far below the market rates.
Well, the tenants are never happy with the percentage increase that unless it's 0%, which happens sometimes. So the tenants aren't happy. The landlords aren't happy with the Rent Guidelines Board decisions. But why is Cedar Point like a rent stabilized apartment? What's the similarity? The landlords are saying that one of the aspects of private property was you have the right to exclude people from your property. And the Cedar Point people had the right to exclude union organizers. And the landlords are saying, well, we have the right to exclude tenants. Yes, we gave the tenant one lease. That's true. But why should we have to give the tenant a renewal lease?
Or a lifetime of leases.
Because those leases could be renewed and renewed and renewed unless the tenant did something wrong. But both the Eastern District of New York and the Second Circuit found in favor of the government. The Eastern District said there's a bundle of property rights consisting of 3 strands. 1, the right to possess the property, that is retained title. 2, the right to use property. 3, the right to dispose of property, that is to sell it. So the court said to be a physical taking, the property owner must be deprived of all 3 strands of the bundle. But the property owners of rent stabilized property do retain the right to possess, to retain title, and the right to dispose of, to sell. And so they have 2 strands. So that's not a physical taking. And there are many precedents which stand in favor of governmental rent regulation. It's called a land use regulation.
And in New York City, these laws resulted from those emergency tenant protection acts because there would be a shortage of affordable apartments had those laws not been in place.
Right. There was declarations of emergency that there weren't enough vacancies, but these declarations of emergencies have been made for about 50 years now.
And is there some magic standard, like 2% vacancy, 5% vacancy? Is there some
5%,
number?
I think it's 5%, yeah.
So do landlords allegedly keep apartments off the market to try to create alleged more availability or try to reduce the number of apartments that are actively rented? Or they hope that they'll be able to charge more for those apartments someday?
Right, that's a big problem. There is a law that was passed in the Assembly and the Senate, but it is not going to the governor's desk. There's not enough support for it. It's an anti-warehousing legislation. So many landlords are saying, I just don't want to be involved in rent stabilization. I'm not going to rent. That's all. Because once I give a lease to someone, I have to give a renewal lease and a renewal lease and a renewal lease. In my opinion, I think that we're not that this is the rent stabilization law is not a taking under the Fifth Amendment of the Constitution of the United States. But if the anti-warehousing law passes in the state of New York, I think that would add a lot of fuel to the fire, and the U.S. Supreme Court might find that to be a taking. It might rise to the level of a taking. That might be a regulation that would go too far, in my sole opinion. I have no, I'm not citing to any case or authority for that.
I just want to remind the listeners, we're talking with attorney Linda Rzesniowiecki, and she's a landlord-tenant attorney and primarily represents tenants and some small landlords in most of the courts of New York City and in other nearby places as well. And she's talking about a challenge to the Housing Stability Protection Act, which is essentially the rent control or rent stabilization laws that landlords are making to try to remove those controls, which keep many rents for hundreds of thousands of apartments at an affordable level, even if that level is below what the market rate might be. And you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. If you missed any portion of this program or want to tell someone else about it, just go to the podcast at nccradio.org. So, Linda, was there something else you wanted to mention about the history and back and your predictions as to what might happen in the court?
Right. One thing I should back up and say, I forgot to give my website address. It's www.landlordtenantlaw.net. That's how you could find me. www.landlordtenantlaw.net.
And of course, at that site, you would have information about this issue and about the rights of tenants and also the small landlords.
Lots of information on that website. So basically, the Eastern District and affirmed by the Court of Appeal, the Appellate Division, said, look, landlords, you're not giving us the specific facts. We have to go building by building, landlord by landlord, to know what's the economic impact of the regulations on each of these buildings. And look, you haven't done that. You haven't done that, landlords. So that was the main reason why the Eastern District of New York threw out the landlord's case. So
they didn't find there was sufficient grounds to visit the merits of these issues, which they may come back with at some point, with a more detailed position.
Right. There were a couple of plaintiffs. There was one plaintiff who bought their building in 1950 in total ignorance of the rent stabilization law. And then the rent stabilization law happened in 1969. The Eastern District said that particular plaintiff, I'm sorry, whose name I forget, is allowed to go forward in the Eastern District, and there has to be discovery about the economic impact upon that particular landlord. But the landlord who bought in 2005 knew darn well that there was a rent stabilization law, and that sometimes the New York State Legislature passes a bill in favor of the landlord, sometimes in favor of the tenant, and it goes on and on like that.
And I guess if the landlords can make a sufficient case for a rent increase, there is a possibility they will get it, and that will help them to balance the books.
Right. The law could change in the landlord's favor at some point.
Now, when will we just have a few minutes left in the program. What's the first thing we're going to look for? That will be whether the Supreme Court takes up this appeal. And when are we likely to hear about that?
Not before October, I'm sure, because that's when the Supreme Court comes back. And I am concerned because this court did overturn a 50-year precedent, Roe versus Wade, and who knows what they might do next. They're a renegade court.
And they're more concerned, maybe some people say, about business interests rather than tenants.
Right, more concerned with employers than employees, as in Cedar Point. So there you go. But the Eastern District did say regulations could get so tough that the new regulation will be the straw that breaks the camel's back. The question is there going to be a regulation or a law coming up in New York State in the future? That is the straw that breaks the camel's back.
And do you see anything on the horizon that could be the straw that breaks the camel's back?
That if that anti-warehousing law ever comes to the forefront, I worry about that being the straw that breaks the camel's back.
But could that also be a housing emergency, that it's inappropriate to keep rental units off the market when there's people who need housing?
That's a good argument. It's certainly a good argument. But it might be landlords' right just not to participate in the system. But you make an excellent argument.
And not to have their private property taken over that way. Linda, give us your website again.
I am Linda Rzesniowiecki. They call me Linda. My website is www.landlordtenantlaw.net. N-E-T.
And I just want to thank you for giving a very interesting presentation about this very complicated matter, and it has different sides to it, and we'll have to stay tuned to what happens in the Supreme Court in the fall and the coming months. And I thank you for being a guest on Law You Should Know. And if anyone missed the program, the podcast is available at nccradio.org. And please join us next week at this same time on 90.3 WHPC, the voice of Nassau Community College, for another program on Law You Should Know.